What's the fallout now that Judge Curry has ruled that Lindsey Halligan is an illegal U.S. attorney? See, there are illegals in America. They just happen to be the U.S. attorneys that Donald Trump appoints. Now that she's been kicked, there's a vacancy. The district court judges got to get together to fill it. Donald Trump is working hard to oppose it. The indictments of James Comey and Letitia James, they're in the trash bin. Will they be picked up by the presiding judges to also dismiss them with prejudice, not just without prejudice, to make sure they never come back again? What's the difference between without prejudice and with prejudice? Why did Judge Curry only dismiss the indictments without prejudice? Is there a difference between what happened to James Comey and his statute of limitations for perjury case and the one for Letitia James? There may be. We break it all down for you on Legal AF the podcast. And here's a clip. So why don't we kick it off with a very brave decision by Judge Curry in sitting by designation in Eastern District of Virginia, but regularly sitting in South Carolina. And right before Thanksgiving, as she promised, she made a ruling about whether Lindsey Halligan was invalidly, illegally appointed or not. And then if she was, what she was going to do about the indictments. That's separate and apart from judges like Nachmanoff and Walker, who are the actual trial judges for the two prosecutions, about what they're going to do about the indictment and closing the criminal case if they find selective prosecution, vindictive prosecution, abuse of the grand jury process, constitutional violations of rights, and that type of thing. So why don't you bring our audience up to speed about Judge Curry and then what happens next with the Eastern District of Virginia prosecutor position?
Yeah, so the issue that was before Judge Curry was a very discrete issue, and that's whether Lindsey Halligan was validly appointed as United States Attorney for the Eastern District of Virginia. And just to remind everybody, the United States attorneys across the country, although they are inferior, they're considered inferior officers, still require, because this Congress passed a statute that says it requires them to be appointed by the president with advice and consent of the Senate. And because that can sometimes take time, they passed another statute that says that the president can appoint someone interim for 120 days. And because obviously, like I said, that process can take time, or looking for someone, or there could be a vacancy. So you can appoint someone temporarily for 120 days. But the statute specifically says when that time expires, what happens next is district judges are the ones who choose the United States attorney. Now, Trump basically thought that because that statute has two sections, one saying that you can appoint someone in interim, that you can just keep doing it. And every time you do it, the clock restarts for another 120 days. But what happened here was Trump nominated Eric Siebert, who was going to be the United States attorney under Trump. He was Trump's nominee. But his 120-day period expired. So when that happened, the district judges in Virginia voted and made him the United States attorney, exactly how the statute is supposed to work. And unfortunately, when he and all the career prosecutors in that office looked at both the Comey case and the Letitia James case, said, you know what, there's no case here. There's nothing to bring. We can't prove any case beyond a reasonable doubt. No crime occurred. Everybody agreed and refused to prosecute the case because they had prosecutorial ethics and integrity. And when that happened, Trump either fired Siebert or he resigned, depending on whose side you believe, and install Lindsey Halligan into the office, somebody with no prosecutorial experience whatsoever. And she was an insurance lawyer. She represented Trump personally. And the people are saying that the defense attorneys for Jim Comey and Letitia James brought these actions saying that's illegal. She was unlawfully appointed. And And so, as you said, this went to Judge Curry, who is not an Eastern District of Virginia judge. But since all of the district judges in Virginia had voted to install Eric Siebert, they were conflicted out of making this determination. And so they had to do it out of district, and Judge Curry was appointed to the judge. And Judge Curry did a very tight analysis of the statute and interpreted case law and basically said, sorry, if you look at statutory interpretation and all the case law, it's very clear how this works. The statute is first you do this, then you do that. So first you appoint it. When the term expires, then the judges get to do it. And that she was unlawfully appointed. Therefore, she was not the United States attorney at the time that she voted this indictment. P.S. She was the only one in the grand jury. She was the person who signed the indictment. So but for her, this would not have happened. And if she's unlawfully in there and doesn't have the authority, it would be like me or you going into the grand jury. We're just normal citizens. We have no power. We have no authority. And he basically said, since she was invalidly appointed, the indictment is dismissed. She dismissed it without prejudice. So there's with prejudice, without prejudice. With prejudice, it means that you can never bring the case again. The case is over forever. Without prejudice means you can bring the case again, but the statute of limitations has run. And there's a footnote in her decision that basically says, look, if you're invalidly appointed, like I said you are, that doesn't stop the clock. So it looks like the statute is run and that the case against Comey is gone forever. We'll see. I'm sure all of this is going to be litigated and appealed, but Judge Curry found that the statute is unambiguous, and once the term expires, the district court fills the vacancy, and that's that. And so it's a great decision. It's very clear. And it is, I think, going to be really hard to interpret this any differently, even on appeal. But the question remains, what happens to all the other motions that were in front of the trial judge, right? Whether it's Nachmanoff or Walker, as you said, what happens to the dispute over the grand jury materials, the vindictive prosecution, all of the various motions that were pending before those judges. And I wonder if you have a different view of this, but I don't see how those things can necessarily be ruled on because there's no case in front of those judges. There's nothing on the docket. There's no way to rule on them, although a complete record has been made, right? They've briefed these issues. They've had hearings on these issues. So in that regard, I think they're covered. But what is your thought on what they?
I think they can still go forward. I don't think the criminal case has been closed. Clerk hasn't closed the case. There's a ruling that Lindsey Halligan is invalid as a prosecutor, and like fruit of the poisonous tree, everything that she did or touched is void. Citing to Judge Cannon, which I thought was interesting in the order, citing to Justice Alito, and back when he was a young lawyer in the White House counsel's office, for the proposition on remedy that, which is what we always thought she was focused on with looking at the grand jury transcripts, about what do I do? And once I find that she's invalidly appointed, what do I toss the indictments, in this case without prejudice, although for Comey, as you said, has a different impact because they're out of time. And the invalidity of the indictment, I think, is terminal to the case being brought again. I don't think it can happen again the way that she's analyzed it. But in terms of if I'm Nachmanoff or I'm Walker, I'm like, all right, well, she's gone. But let's look at the grand jury process and let's look at whether vindictive prosecution was present sufficient that not only that, but I'm going to dismiss it with prejudice. In other words, don't even bother bringing in another Lindsey Halligan, God forbid, or even the one appointed by the judges of the district court, because I am finding that in the one chance that she had, it demonstrated vindictive prosecution. and she was illegally appointed as part of that, but I'm going to close the case and I'm going to do it with prejudice. I think that's similar to what you actually thought was going to happen when you said she's not going to dismiss the indictment. She's going to leave it to Nachmanoff and Walker to do something with on the merits, on the substance, so to speak. That's sort of what she did.
Yeah. I mean, yes, but she dismissed the indictment. That's the problem, is if the indictment is, it'll just be interesting to see how they sort that out.
Without prejudice. If it was with prejudice, I would agree with you. Case closed, clerk close the cases. Yeah. Without prejudice, that puts the ball back in the government's court to try to figure out a way to get a prosecutor not appointed by them under 546 to go and make a decision to go do this. And that's not always easy. I don't think any self-respecting prosecutor like you used to be is going to prosecute this case. And then they're going to be left arguing naked argument to some higher authority that their interpretation of 546, although rejected in Nevada, rejected in New Jersey, and soon to be rejected in the Third Circuit Court of Appeals, is the right interpretation of plain statute that says it's a single-use ticket. You get one appointment for 120 days. After that, it gets turned over to the federal judges of the district, and it's a little bit of a power split there. Now, some people have asked me, isn't that a violation of the separation of powers? Like, how does the district court get to pick a executive branch officer in the form of a prosecutor? Listen, our nation has been doing it apparently since the Civil War. There's been some version of this sort of power sharing when it comes. I guess the way the balance is Trump he always gets his pick to be confirmed by the Senate. And he also gets this extra pick for 120 days, but he doesn't get unlimited 120-day picks to avoid the appointment clause. And therefore, somebody's got to fill the job. So we'll let district court judges, who sometimes pick special prosecutors, we'll let them do it. I think we're out from under a separation of powers issue, but that's what they're going to argue. Just like they argued that, the statute's been around for 90 years for the Federal Trade Commission or the National Labor Relations Board, but it really has always been a violation of separation of powers. We'll see. But for right now, I haven't gotten word yet that the judges have the judges met to pick the replacement yet. They should. Yeah, I mean,
they really should. Exactly.
Quickly.
Exactly. So, yes, but I hear what you're saying. I just don't know the mechanism, how they are going to be able to rule on this when there's no indictment before him. But it'll be interesting, right? It'll be interesting to see, do they have to wait to re-indict before they can make these arguments? Or can Nachmanoff still rule on these issues?
I think he can, but we'll have the debate.
We'll see. It'll be interesting to see.
There's no indictment in front of him. The criminal case is still in front of him because it was done without prejudice. So as long as he still has jurisdiction, then my argument would be, if I were now Comey, I would bring a motion to dismiss with prejudice the indictment for the running of the statute of limitations. He has to be able to rule on. Let's use that as an example. Nachmanoff has to be able to rule on that. Who would rule on it? So in other words, they want to preclude the government from, even under any prosecutor, from running back in because of the running of the statute of limitations. That's clearly an issue of law that can be decided by Nachmanoff right now.
Yeah, I think he has to wait for another indictment. Right now, there's no case. She dismissed the case. She dismissed the indictment.
No, there's no indictment.
There's nothing. There's no but there's no charging instrument.
Yeah, right. But it's without prejudice, so the case is still alive until they re-prosecute. And if they're all there together, I mean, we can debate this all night long. But I've had plenty of cases where the complaint gets dismissed without prejudice, doesn't close the case, and she didn't order the case be closed.
Yeah.
So the case is still open on the docket. And if I'm Comey, the next piece of paper I write is to stop the next indictment, not wait for it, and say, you cannot, under all the other things we talked about. But a new thing, Judge, the statute of limitations has run. The indictment has been declared to be invalid. Therefore, it didn't stop the clock on the SOL, the statute of limitations. And you need to bar them from bringing me back through the mud with another indictment if they get another kooky prosecutor. That's what I would do. We'll find out.
Yeah, I mean, Comey could have asked for the indictment to be stricken, and then I would agree with you. but he asked for the indictment to be dismissed. And that's what she did. You're right. It's without prejudice means they can bring it again, except for the statute of limitations. But
Right.
we'll see. We'll see what happens. But I'm not as, I think this case might be dead without us being able to review, without those rulings to happen. That being said, I think that they might appeal this, right? And so if this gets appealed and the indictment goes back, and that's what I think was smart about Nachmanoff, right? Is that if this gets appealed and the Supreme Court rules that Lindsey Halligan was validly appointed and these things are wrong, all of these issues have been briefed already, and Nachmanoff then, I think, could, because then the case will go back down to him, can then rule in these other areas. But we'll see. We'll see how it goes, but it's very interesting.
Welcome back. We sit at the intersection of law and politics, so you don't have to, on Wednesdays, on Saturdays, at 8 p.m. Eastern Time on the Midas Touch Network, and the commercial-free versions over on Legal AF Substack. You're on Legal AF YouTube channel. Take a minute, hit the free subscribe button. Help us continue to grow this channel. We're trying to get to 1 million by before Christmas or Hanukkah. And that's Legal AF, the podcast. So if you have a moment, find out if you're a subscriber. If you're not, become one. Come over to Legal AF Substack. Become a member there as well. And if you can pull it off, that is what pays our bills. That's what keeps our editors from quitting. That's what gets this entire Legal AF ecosystem up and running. So until my next report, I'm Michael Popak. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.